We'll get started. Welcome to Washington Legal Foundation. My name is Glenn Lammy. I'm Chief Counsel of the Foundation's Legal Studies Division. For those of you not familiar with the Foundation, we are in our 41st year of free enterprise advocacy and education through a number of different vehicles, including litigation, regulatory commenting, publication of short papers in programs such as this one. We're very active on the issues that we're going to be discussing today, both in court and by putting out publications. So we're pleased to be adding this program to our repertoire of advocacy and education devices on this issue. 50 years ago, Congress passed a law empowering a panel of federal district court judges to transfer multiple lawsuits alleging similar claims against common defendants to one court for the purposes of pretrial proceedings. The use of the MDL device and the time cases spent before an MDL judge were meant to be limited. Today, however, and certainly for certain types of lawsuits, MDL has become the norm, and few cases are ever transferred back to the original courts. The group Lawyers for Civil Justice recently reported that as of 2017, lawsuits vacuumed up into the MDL process constitute nearly half of all civil litigation in the federal courts. 90% of cases in the MDL process are products liability claims, and 24 current MDLs contain more than 1,000 individual cases each. The nature and size of MDL proceedings make it difficult for judges to apply some federal procedural rules, so MDL judges often devise their own rules. As a result, MDL practice is marred by the lack of consistency and transparency, shortcomings that some argue have contributed to the growth of MDL proceedings. 1 year ago, the Federal Advisory Committee on Civil Rules created a subcommittee to review several organizations' proposals relating to the rules that apply to MDL. That subcommittee will be reporting on its work to the full advisory committee at a meeting tomorrow. We're pleased to have with us today the general counsel of one organization that submitted recommendations to the advisory committee, as well as two civil litigators that have been directly involved in both defending cases deposited into the MDL and advancing ideas on how to improve the MDL process. I'm going to introduce them in the order in which they're going to present. Alex Dahl will be leading off, who's the founder and CEO of Strategic Policy Counsel, PLLC in Washington, D.C. He serves as outside general counsel to Lawyers for Civil Justice. Previously, Mr. Dahl was Deputy Staff Director and Senior Counsel to the Senate Judiciary Committee and worked as an Assistant U.S. Attorney in the District of Columbia. Following Alex will be Mary Nold Larimore, who's a partner with Ice Miller in the firm's Indianapolis, Indiana office, where she serves as co-chair of the Drug and Device Group. Ms. Larimore's primary practice concentration is in litigation, focusing on product liability, toxic tort, and commercial litigation. She was the first woman from the state of Indiana to be inducted into as a fellow in the American College of Trial Lawyers. Finishing up today will be Stephen A. Wood, who's a principal with Chuhak, Tecson in the firm's Chicago, Illinois office, where he leads the firm's litigation practice group. He focuses his practice on complex civil litigation, including a wide range of commercial disputes, mass torts, and products liability matters. Mr. Wood is a former captain in the U.S. Marine Corps. WLF is proud to have him as one of our blog's featured expert contributors, writing commentary on the False Claims Act. Our speakers are going to be using the PowerPoint slides, which you'll be seeing on your monitor if you're online. If you're here with us in person, we have copies of that available to you. If you'd like to get a PDF of it and you're online, just shoot me an email at glammy@wlf.org. Also, you'll be able to ask questions if you're online at the end of the program using a device that's to the right of the viewing screen. So with that, I will pass it over to Alex. Get started.
Thank you, Glenn. It's a great honor to be here at the Washington Legal Foundation, and with you, Glenn, you've done a lot of great work on many topics, including multi-district litigation, and really pleased to be here, and also with this incredibly talented group of panelists, so thank you. Before we start on the topic of multi-district litigation, I would like to invite you on a thought experiment with me. Halfway around the world, there is a small country which for the first time is going to establish the rule of law. For whatever reason, they have not had it in the past, and they're undertaking to understand what rule of law should mean in their new country. They ask three questions. The first question is, should we have a written group of procedural rules that apply uniformly in all of our courts and to all parties in those courts? Or, because cases differ, should we have a system where judges make up procedure on a case-by-case basis in order to tailor those procedures to fit with those cases, allowing for experimentation and innovation. The second question they ask is, should we have a system of vetting claims that come into our courts in order to make sure that there is some merit to them before they are processed by the judicial system? Or should we ignore any distinction between meritful claims and meritless claims and wait until the end of the process to make any decision about what cases stay on the court's dockets? The third question they ask is about appellate review. And the question is, should we develop a system of appellate review in our country, not only for the purpose of checking judges' individual power, but also to develop case law that can provide guidance to future courts and parties in handling cases? Or is it better to allow judges more power and to avoid the delay that inevitably comes with appellate review and allow judges to more fully exercise their individual creativity in each case? Now, if you answer these questions as I think you might, in favor of written rules, vetting of claims, and appellate review, I'd ask you one more question, which is that even if your answers are along those lines, would you still favor a separate system of law that has the other side of those questions that's reserved just for the biggest and most significant cases, the ones with the most parties and the highest economic value, and have those cases deal with a system that has no uniform rules, no vetting of claims, and no appellate review? So, welcome back to the United States, the end of the thought experiment, but you might be a little shocked to learn that what I have just described can be used to describe what is happening in MDL cases today, because they are marked by a practice of not following the federal rules of civil procedure, of not vetting claims, and very, very few times is there appellate review of the key decisions in those cases. And this is not a small problem. MDL cases consolidated into MDLs, as Glenn mentioned, are almost half of the federal civil docket today. 47% of the federal civil caseload is in MDL cases. And this is not a static figure, it is a quickly growing figure. The number of cases in MDLs has tripled in the last 15 years. So, what are the solutions? Well, there are a number of problems and a number of solutions are needed. At Lawyers for Civil Justice, we're focused on the solutions that can be brought about by changes to the federal rules of civil procedure. We start with the basics of Rule 1, which says that these rules govern all civil proceedings. And our view is that MDL cases are not governed by the federal rules of civil procedure as much as they should be. The federal rules of civil procedure, which were adopted in 1938, provide an incredible value to our system of justice: transparency, clarity, uniformity. And we think that taking into account those principles and ideas, that a small number of modifications to the existing rules are needed to bring MDL practice within the fold of the federal rules of civil procedure. And we have made a handful of suggestions to the Civil Rules Committee. I'm just going to mention these, introduce them to you, and then we will discuss them further. So we start with pleadings. Rule 7 lists the pleadings that are allowed in federal courts. But people who are familiar with MDL practice know that there are pleadings that are commonly used in MDL cases that aren't listed in Rule 7. We think this is a no-brainer. List the pleadings that people are actually using in those cases, including the master complaint and individual complaints in cases consolidated for MDLs. The second proposal has to do with early vetting. The civil rules have many ways of getting at the quality of claims in the system prior to final judgment. This was a very important idea to the drafters of the original Federal Rules of Civil Procedure. Those of you who are acquainted with the rules, 8, 9, 11, 12b, 56, you'll recognize that all of these go to testing the merits of claims for the purpose of making sure that our judicial system case dockets are not overwhelmed with claims that do not belong there. What happens in many MDLs is that rather than applying these rules, courts use ad hoc procedures. Most of them don't work in the way that the rules do. Even the ones that do work lack the consistency, clarity, and transparency of rules that are written down in a book, taught in law school, and available to all practitioners. The next topic is interlocutory appellate review. As I mentioned, appellate review is very rare in MDL cases, yet these cases can involve thousands of people's claims and huge amounts of money. And there are a small number of particular case dispositive type of motions in these cases that appellate review would be very helpful for. Not only as a check on the trial judge's power over the case, but also to develop the case law to give more guidance to other judges and future parties. I'm talking about a small number here, and our proposal is drafted very carefully so that it is not going to allow numerous appeals and is focused on the ones that could truly help resolve the cases more quickly rather than all other kinds of motions. The next topic is bellwether trials. As Glenn mentioned, the statute that created multi-district litigation says that the purpose is consolidation for pretrial cooperation, pretrial coordination, thank you. Yet it is very common in these cases for judges to hold trials. A couple of problems develop with this, and but the net result of those problems is that it is really rare that the cases that are tried are the ones that really demonstrate what the claims of the cases are about. One of the reasons, of course, goes back to the early vetting, which is that nobody knows what those cases are because there's not enough discovery going into the claims in the case for anyone to understand what the case is about, and therefore what cases could be bellwether trials to represent the case. And the other reason is that a lot of judges use a system of picking bellwether cases by asking the plaintiff side to recommend some, the defense side to recommend some, and then the court picks some. A process that is not likely to come up with the ideal case for understanding the entirety of the claims. Our final proposal that I want to address today is for disclosure of third-party litigation funding. Now, third-party litigation funding is a big topic, and our proposal does not limit this disclosure only to MDL cases because it is quickly growing and widely used in other kinds of cases as well. But we are asking simply for disclosure of these agreements, not any kind of regulation. We think it's very important for ethical reasons, in the same way that the current rules require disclosure of other entities that might have a material interest in a lawsuit but are not the named party. For example, corporations have to disclose whether other corporations have a sufficient interest in their company in litigation. It is also important for litigation dynamics in the same way that disclosure of insurance agreements, which is universal, common, widespread, well accepted under the rules, has, so that parties will know who really is in the courtroom, what are their interests in the case. And it turns out that there are really no kind of high principles at stake in this debate of whether to require disclosure of third-party funding. The question is really whether that is proprietary information for funders and not something that should be allowed for others to know about. I think that one possible answer which is insufficient, in my opinion, is the idea that judges should be reviewing these agreements in camera, which develops a dynamic that the judge in an adversary proceeding becomes in the position of having to vouch for one side on an issue against the other. It also leads to a dynamic where everybody in the courtroom except the defendant knows who's in the courtroom. If you're going to have the plaintiffs and the judge know who's in the courtroom, it makes sense to have the rest of the parties involved as well. So those are my introductory comments. Glenn, thank you again for allowing me to be here. I'll turn it over to Mary.
Good afternoon. I thought I would start by giving just a little bit of context and perspective to the MDL issues. I was involved with the very first mass tort in this country that involved a product, which was the Dahl Shield, when I started practicing law back in 1980. And as a consequence of that litigation, and of course 38 years later continuing to be involved with mass torts, when I first started practicing, there were a couple of things that were a constant. The first was that every plaintiff had actually used the product and claimed an injury from the product. And the second thing was that that plaintiff had an actual attorney-client relationship. Looking back, that's absolutely quaint. That doesn't happen anymore. The chances that the person actually purchased the product and used the product is a crapshoot. Whether they actually have any medical expenses or medical injury that's documented in any way from the product, another crapshoot. And whether they have an actual attorney-client relationship, again, another crapshoot. I was on a panel with a group of professors when I said that, and the response was, well, that's silly, Mary. You know, when you've got thousands of plaintiffs, you know, how could you have an attorney-client relationship? And my response was, when you have millions of dollars to spend on advertising on 1-800-BAD-DRUG on 3 o'clock in the morning, then you ought to ensure that you have enough staff so that individuals can call your office and find out whether they actually have a claim before you file it. So let's talk about what's happened with the MDL. Is it time to change the MDL playbook? And I call it a playbook because, as Alex so aptly set up, so many of these rules are in a playbook that those of us who do this regularly are very familiar with. But lawyers from the outside who, you know, may have, you know, 5 plaintiffs in the state of Idaho and get those clients pulled into an MDL, this will be very unfamiliar territory for them. And there's no easy way to figure out how to navigate this. One of the, while LCJ is working very hard on an MDL reform, there are others that are involved too. Because the question isn't just, do the lawyers working well within this system, and are the judges working well within this system? The question is, does this playbook work for our clients? And that question is a very different question for the as part of the defense bar, I think the answer is in many respects no. And the scholarly work that is being done by some professors around the country are looking at it from the plaintiff's side and coming to some of the same conclusions. Professor Birch and Professor Williams wrote an article in Cornell Law Review in 2017, and it's called Repeat Players in the MDL, the Social Networks. And they do a very empirical job of describing what can best and most quickly be described as a good old boys network of, repeat players who are very involved in this litigation, who have established norms. And I wrote down one of the quotes because I thought it was so important. The prevalence of norms over formal legal precedent or rules give repeat players more opportunity to influence litigation. And when formal rules are scarce, socially constructed rules and norms end up inputting legal outcomes. So as we're looking at potential reforms, what are some of the things that we're looking at? Master complaints and short form complaints. That's one of the very first things that happens when your client is the unfortunate, ends up being the target of a mass tort and ends up in an MDL. And the first thing that everyone decides is, gosh, it's so much work for, to answer every complaint. And of course it is, with thousands and thousands of complaints. So they've adopted this procedure, which is not recognized in the federal rules, but can make a lot of sense. And that is, we'll have a master complaint, the plaintiff will file a short form complaint. The short form complaint is usually, check the box. You check the box, how many causes of action do you want to claim? They check all these boxes, and that's pretty much it. And then there's a form, master answer that's filed, and then you just move on to the next step. Now, in a regular case in federal court, if a plaintiff did not identify that they purchased a product, or they had a product implanted or prescribed for them, and that they had a specific injury, that complaint would not meet Iqbal Twombly standards under the Supreme Court. It wouldn't meet just the basic requirements of due process. But in the most expensive litigation in the country, we skip due process and we file these check the box. I was recently arguing before a federal court, on a case that had been remanded from an MDL. And the plaintiff wanted to file his master complaint, short form complaint, and didn't understand why we were objecting. And so I stood up and said, if you do that, then I'm going to have to file a motion for judgment on the pleadings, because the vast majority of these causes of action aren't even recognized in the state of Indiana, and went on down the line. And by the time I was done, he stood up and said, I guess I agree. I guess I agree. Why should we be spending all this time litigating over causes of action that aren't even in the case? So we have a very modest proposal. Let's, because some courts say that, a master complaint isn't a real pleading, a short form complaint isn't a real pleading, you can't engage in motion practice on the basis of that pleading. Let's recognize these as actual pleadings, from which a defendant, if they choose, can do a motion to dismiss. We were involved in a MDL for a client where the vast majority of the cases were dismissed because they did not state a cause of action against brand manufacturers, and they didn't state a cause of action against generic manufacturers. Why shouldn't we be dealing with these preemption issues early, right out of the gate, as opposed to let's just skip over the first step and go right on to discovery? So this is really kind of what happens in an MDL. There are just a huge inventory of junk cases that end up getting amassed. And the more cases, the question is why? Why does this happen? And I think that in this day and age, you have aggregators, and these are individuals that are hired by law firms that, go out and sign up all of these plaintiffs. You have lots of national advertising that is going on. And plaintiffs' attorneys feel that they need to have a lot of cases on file when the MDL starts so that they can get a leadership role. So even though some of these cases are all, not meritorious, and they know it from the get-go, they can still say to the court, oh, I should need a leadership role because I've got a lot of these cases. And One of the interesting things that I found as we have been talking about MDL reform is that judges look at this and say, so what? Like, what's the big problem? We'll deal with all of that at the end. Well, I'd like to talk about why this is a big problem. If a plaintiff does not vet a case, as they're required to do under the federal rules, under Rule 11, you should not be filing a complaint without a good faith basis for believing that it has merit. What ends up happening is the defendants end up in that role. It's the defendants that have to sift through all of these plaintiff fact sheets to see whether they've identified a product. It's the defendants that get to pay for the collection of the medical records to find out if a physician actually prescribed it, to find out if the product from your client was implanted, or maybe it's a completely different product manufactured by somebody else. It's the defendants that have to have lawyers and paralegals sending letters to the plaintiff's attorneys saying, please dismiss this case, it's not meritorious, filing motions if that's not successful, and all of this costs a lot of money. You file deficiency letters as it relates to the plaintiff fact sheets if they aren't filled out completely. We were involved in a piece of litigation with 5,000 plaintiffs, and at one point in time, there were 40 or 50 people in our firm that were taking a good chunk of their day writing these deficiency letters because you couldn't get these cases dismissed until you had gone through all of these steps. And all of these steps were really important in order to get these teed up for dismissals. All of these cases can impact regulatory filings. In different industries, you have time deadlines. If there's a complaint against your product, within 24 hours, individuals have to report that within the company, and all of those reporting requirements cost money. The impact on the viability of the product or the service, the impact on SEC filings, and the constant reporting and auditing that is required, all make these junk cases a problem. So what are some of the solutions? Certainly, change to Rule 20, the joinder rule, isn't the solution, but I think it might be a solution. Currently, plaintiffs' attorneys, when they sign up individuals for a mass tort, you could have a multi-plaintiff complaint with 75 different plaintiffs that could come from 30 different states. Just as they sign them up, they add them to the complaint, and one filing fee for 75 plaintiffs. Would a filing fee for each plaintiff change the playing field dramatically? I think it would help. I do. I think it would help. If they had to pay, $350 or $250, depending upon the filing fees, for every single plaintiff, they would try to find out before they filed it, is this a case that is worthy of filing a lawsuit? LCJ has also put forward an excellent proposal for early vetting. What does it entail? Within 60 days of a case being transferred into the MDL, a plaintiff would have to identify, I find this to be so basic, the product or the service that they claim that they used, and documents that evidence that. So if you had a prescription, give us the prescription. If you had a surgery with a product, give us that. If it is a consumer product, send us, the information from the packaging that you had. But identify what product it is. And, one of the interesting things that can happen in cases where multiple defendants are sued for products that are all within the same class, imagine every single defendant has to report to the FDA on every single plaintiff, even though they only took one company's product, not 5 different companies' product. So out of the gate, tell us, whose product did you use? And out of the gate, within 60 days, and again, this should be information that you'd have before you filed a lawsuit, identify with particularity the specific injury that you've got, and again, provide us with documents. It's really telling. Have you ever gone to a doctor? Who is that doctor? How did they treat you for the injuries that you're claiming in this lawsuit? Now, the plaintiffs have looked at this and said, well, usually when I'm on these panels, there's a plaintiff's attorney member that will speak to this, and he'll say, of course, I never do this. I never, ever file lawsuits that are meritless, and usually the plaintiff's attorneys that are on these panels are not the attorneys that are causing all of this difficulty. But what the Association of, I can't remember what it's called.
American Association for Justice.
American Association for Justice, the old Trial Lawyers Association, has proposed in response to this is, well, let's just come up with an inactive docket. So all of our junk cases that we really didn't vet, that we're not really sure about, we'll file them all anyway, and you can amass this huge, group of cases that you have to report about to your shareholders that 4,000 individuals have sued you. But we won't really look at those. And of course, on an inactive docket, who knows that you will. And while certainly an inactive docket may make sense in a particular piece of litigation, 90% of the time, the vetting is easiest to do out of the gate. It doesn't get easier 4 or 5 years later. The records aren't easier to get 4 or 5 years later. And they say, well, we don't want plaintiffs, or we don't want the judge to be distracted by all these individual motions that are dismissing all of these cases that don't have any evidence, that shouldn't have been filed in the first place. And if you don't want the judge distracted by all of these motions on cases that don't belong in the MDL, then don't file cases that don't belong in the MDL. But I think that this inactive docket, quite honestly, would be a recipe for litigation in perpetuity. Because once you settle the active cases, now you have to figure out what are we going to do with this group of cases that's parked here. Often when we are dealing with trying to wind down an MDL, the plaintiff's attorneys can't find these individuals. They can't find them to get consent to drop their case. They can't get their agreement, or they've been strung along for so long at that point in time, they think that they deserve something, even though they never really should have been involved in the litigation at the outset. So usually waiting till the end, from my perspective, is the approach that's going to take the most time on both the plaintiff side and the defense side to figure out whether that plaintiff was even, should have been involved in it to begin with. Now, I was, before I move on to appellate review proposal, I was thinking this morning as I was, thinking about all these junk cases and, how challenging it is to whittle these down. And in litigation, it can be 30 or 40% of an inventory, that doesn't belong there. And I was hearkening back to a partners retreat that I was at a number of years ago. And our firm is from Indianapolis, and we had gone to Lexington, Kentucky, and we were at the Keeneland racetrack. I don't know if you've ever been there, but it is beautiful. And we're walking up this gorgeous sort of promenade to the track, and out come these horses, and they're just absolutely beautiful. And everybody's standing there as they're getting ready to go into this area where they're really just sort of showing them off. And one of the horses has a very large accident in this promenade, and immediately there's a guy in a little jacket that stands guard over this so that none of the women and men who are walking up, the patrons, are going to step in it. And he gets on his walkie-talkie, and there's a whole army of people, and it is shoveled and washed and cleaned and deodorized, and it was back to absolute perfection. And the senior partner that I was with, who's a senior trial lawyer in our firm, he's now retired, and I tried cases with him, he turned to me and he said, that kind of looks like our job. Our clients hand us this big pile, and they want it dealt with. And dealing with it isn't parking it and giving it to generations and generations of associates to deal with, years down the road. So we're looking for solutions that will deal with these meritless cases early in the litigation. The appellate review proposal is really important. And a great example of why it is needed is defenses that out of the gate ought to be addressed. Preemption, federal preemption is one of those. If a defense files a motion for either motion to dismiss or motion for summary judgment saying this claim is preempted by federal law, and the plaintiff loses, they get to go right up to the Court of Appeals and get a definitive answer. And If the court is right and there is federal preemption, that's pretty much the end of a huge piece of litigation. If a defense files the motion for preemption and the defendant loses, it can be years and years and maybe never before an appellate court gets to look at that issue. If you lose a motion for summary judgment, you can't go up on appeal. You're involved in millions of dollars of discovery, production of millions of records. All of your corporate executives are all being deposed. You've got experts. You've got potential trials, X number of years down the road. And there is no way to get an appellate court to give that a look in an efficient way. And so this review proposal applies to motions that could be dispositive of 50 or more actions. So this isn't just one plaintiff with a statute of limitations issue that's unique to them that would get to go up on appeal. This would actually impact motions that would impact a huge group of cases. One of the big arguments that has been posed against this is that it's going to delay the litigation. And I would just point out affirmatively that because you can get an interlocutory appeal of a particular issue does not mean that a judge is granting a motion to stay. This doesn't come with an automatic stay of the entire litigation. You can proceed with the litigation, but on issues like preemption or a Daubert motion on whether the evidence that the plaintiffs have is adequate to scientifically prove that product A causes injury B, those are the kinds of global questions that we should be in a position to get a court of appeals to review early in the litigation as opposed to late or in many cases never. And finally, I want to talk about the proposal related to third-party litigation funding. I guess this isn't finally, but second to the end. And I think that this is really important as well. The bottom line is if a company has insurance, that has to be disclosed right out of the gate. You've got insurance, and this is what your insurance policy says, and the plaintiff's attorney understands what are the parameters, what are the limits of the insurance, how much is at stake, what are we dealing with here, and if there's settlements, if the insurance company is going to be a party in interest, they have to show up at the settlement conference with the magistrate and be in a position to provide whatever authority they may or may not have. The same thing should happen when there's litigation funding on the plaintiff side. I mean, it just seems to me, what's good for the goose is good for the gander. And the bottom line is that these litigation funders will stand up and say, no, we don't control the litigation, and we really don't have any impact, and we're not really involved. When you look at their websites, it often has a very different approach, because of course they're involved. Of course, hedge fund managers don't give mega millions of dollars and then just, head off to on vacation and hope that it turns out well in the end. Of course not. You're funding litigation to the tune of many millions of dollars. You do have an interest in it, and they should be disclosed early on so that that information is available for both the court as well as the parties, and so that they're present at settlement negotiations as well. And then finally, the proposal for bellwether trials is really pretty modest. And I think that the benefit of the particular proposal that we have is it happens to be completely consistent with the statute. The statute that established the MDL says it's for pretrial, it's for pretrial coordination. And so if you have a statute that says pretrial coordination, shouldn't that be, the rule that it's for pretrial coordination? I think that bellwether trials, there's always a lot of pressure to consent to bellwether trials, and I think that over time people are really questioning, what the value of that is. There's a whole host of different mechanisms that have been utilized. Plaintiffs pick 10 cases, defense picks 10 cases, some cases are picked randomly. But universally, what typically happens is if it's a great defense case that's up for trial first, it ends up getting dismissed voluntarily by the plaintiffs because they want to make sure that the first cases up are their best cases. And so these really don't end up being sort of representative trials to any extent. And I do think that when you're looking at MDL reform, one of the sort of unspoken rules in the playbook is that the court really does have a strong interest in pushing the defense to a out-of-court resolution. And so many of these aspects of MDL practice, whether it's dispositive motions, Daubert motions, preemption motions, bellwether trials, are tools that they have in their toolbox to push the defendants toward that end. So I'm going to turn it over now to Steve, who's going to talk about some other interesting ideas for reform, and very much appreciate you being here.
Thank you, Mary. I'd like to thank Glenn and the Washington Legal Foundation for inviting me to participate in this event this afternoon, and I'd like to welcome the people who are here in person and anyone who may be looking online. We started out with some statistics that Glenn offered, and I was interested in, as I was preparing for this, in getting updated information. So yesterday I went online to get the most current MDL statistics, and if anyone is interested and you haven't looked this information up yourself, all you have to do is Google JPML and MDL statistics report, and you can find the current statistics on multi-district litigation proceedings with a comprehensive listing of every single pending MDL there. And I think this is updated. The data I have is dated October 15th, so it's very current. It's only a couple of weeks old. This is updated on a fairly regular basis by the JPML. And so, as Glenn mentioned, there are 24 MDLs currently pending out of a total of 211 MDLs, of 24 that have at least 1,000 actions in the MDLs. And of those 24, 23 of the 24 are products liability cases. And of those 23, 19 involve drugs or devices. So we frequently talk about these reform measures in the context of mass tort litigation. But the reason, I think, is that these large collections of cases, the largest MDLs, typically involve pharmaceutical or medical device products. In fact, the only MDL that I could find that was of significant size that did not involve product liability litigation arose out of the Deepwater Horizon disaster, which is currently pending in the Eastern District of Louisiana. So I wanted to provide a little bit of historical context here. I'm all about historical context. So, in the 1980s and 90s, or 70s even, the class action mechanism was the preferred vehicle for those seeking to bring large numbers of claimants before a single court. And that changed for a few reasons. One of them is that, I'm not necessarily approaching these chronologically, but in 2005, Congress passed the Class Action Fairness Act, which made it easier for the removal of state-filed class actions to federal court, taking them out of the hands of state court judges who perhaps might have been more inclined to certify a class. So, in addition, there were a couple of very significant U.S. Supreme Court decisions in the 1990s predating the passage of CAFA, the Amchem and Ortiz decisions, which had an effect on class action practice. In both of those cases, the Supreme Court rejected the certification of large classes of personal injury plaintiffs for purposes of settlement. In the Amchem case, which I think was decided in 1995, I don't have well, it's on the slide there actually. It was in 1997. In the Amchem case, the Supreme Court decided that you couldn't certify a class under 23B3 without establishing the requirements for class certification under 23A. That was a settlement class that had been certified involving a number of asbestos claimants and a number of defendants, and so the certification was improper there because you had to establish the requirements for class certification under 23A, and those requirements weren't met. In the Ortiz case, this was a limited fund class that was certified under a different part of 23, of Rule 23, and the Supreme Court found that that class wasn't properly certified either. And so it made it, the upshot of those two decisions was that it was going to be difficult in a personal injury context because of a lack of predominance or a lack of adequacy for personal injury cases to lead to class certification and ultimately settlement. So, these developments probably were the best thing to happen to mass tort plaintiffs' attorneys because they could, in essence, get the same benefit that they got from class action treatment, bringing masses of claims together, confronting defendants with enormous liability without the burden of meeting the procedural requirements for class certification and then having to defend the class certification on appeal if necessary. All that was needed to be established was that under the MDL statute, cases have a common question of fact. That is the only requirement. Now, in addition to that, I actually probably advanced this a little bit too soon. There's the operative language in the last bullet point on that slide. In addition, MDL treatment is supposed to serve the convenience of the parties and witnesses and promote the efficient conduct of the action, but I think those requirements are really secondary once you achieve a certain critical mass of cases. So, one significant concern with the current state of affairs is that certain pivotal rulings in MDL proceedings have the potential for sweeping consequences for the parties as well as the development of the law. And you've heard Alex and Mary both talk about a proposal that the LCJ has put forward for amending civil rules to establish that there should be a non-discretionary opportunity for interlocutory review in certain cases. So I'd like to talk about a slightly different take on this. And this is not an LCJ proposal, but it is something that I think could be considered either in addition to rules amendments or perhaps as an alternative to hopefully get the same sort of benefits that you might get from non-discretionary interlocutory review. And that is the idea that you could appoint more than one judge at the trial court level to manage one of these larger multi-district litigation proceedings, right? If you look at the language from Section B of the Multi-District Litigation Statute, it refers to judge or judges. So there is statutory authority for assigning a multi-district litigation proceeding to more than one judge. Now, there is, as I said earlier, I'm all about historical context, and there is certainly precedent for having multiple judges preside over a case in the district court. And in fact, this really arose as a matter of statute. In 1910, Congress passed the Three-Judge Court Act, and this was a response to a Supreme Court case that upheld a decision by a district court judge, a lone district court judge, finding that a state law was unconstitutional. That was troubling to a number of members of Congress, that one state court judge could decide that a state law was unconstitutional. And so the Three-Judge Court Act came into existence, and it required that whenever the constitutionality of a state law was being challenged, 3 judges needed to preside over that case. Later, the law was changed to make it applicable to federal laws in addition to state laws. And ultimately, by the early 1970s, the Three-Judge Court Act was essentially shelved. And in its current state, it requires the appointment of 3 judges to preside over litigation in the district court when it's required by a particular statute or when there is a challenge to the boundaries of a particular legislative district. All right? And so I think what's significant about this is that in those instances where elected officials have chosen to require 3 judges at the district court, it reflects a value judgment that these matters are particularly sensitive or important enough that we need to deviate from the default rule where 1 judge presides over the case to minimize the possibility of error and to promote confidence in the judicial system. And I think the same rationale can apply to the decisions that are made by judges in large multi-district litigation proceedings. And this is a quote from a commentator talking about the benefits of multi-judge district court proceedings, lending the dignity required to make such a decision palatable. The extraordinary nature of the procedure shows that the federal courts recognize that important and delicate interests are at stake, and more importantly, the presence of 3 judges ensures greater deliberation with less chance of error or bias. So, as I said, the thing about this procedure is there's no requirement for rule amendment or further statutory action. The authority already exists. Now, we've been talking beforehand, Alex and Mary and I, about whether this had ever been invoked by the JPML previously. And we think we know of one instance where perhaps in the case of the Microsoft antitrust multi-district litigation, there may have been more than 1 district court judge. I think Judge Motes in the District of Maryland was originally assigned responsibility for that MDL. We're a little bit fuzzy on the exact circumstances, and we need to investigate that a little bit more. So apart from that, there is one other instance that I can cite to where something like this was done, and it wasn't actually in an MDL proceeding. It occurred in the Middle District of Florida, and it arose out of the Engel progeny litigation that was pending in Florida. You may recall that there were a number of product liability lawsuits filed by smokers and their family members against tobacco companies. A class was certified, the Engel class. Ultimately, there was a trial resulting in an enormous verdict. This was appealed, and the Florida Supreme Court eventually decertified the class. But in doing so, it gave the class members a year to refile individual claims, and many of them did. Some of them did it by way of multi-plaintiff joinder. Thousands of cases were filed in state court. The defendants removed many of these cases to federal court, and there ended up being in excess of 3,000 cases and 4,000 representing 4,000 claims of 4,000 plus plaintiffs in the Middle District of Florida. The interesting thing about this litigation is that a couple of the defendants had actually filed a motion with the JPML seeking multi-district litigation treatment, and it was denied. And the reason it was denied, I think, is that the Judicial Panel on Multi-District Litigation felt that the litigation was too mature for MDL treatment. Most of the common discovery benefits had already been achieved in the state court action, in the class trial, and so mainly individual discovery remained, and it didn't warrant MDL treatment. So these judges in the Middle District of Florida were confronted with the prospect of seeing thousands of cases through to final resolution in their court. Remand, even though remand is almost unheard of in MDLs, it wasn't even a theoretical possibility in the Middle District of Florida in the Engel progeny cases. And so what happened is that these judges got together and decided to divide up these cases equally amongst themselves. And since they were all facing a huge docket, in excess of 1,000 cases, that they should coordinate their efforts to manage these cases. And if you look at the transcripts in the proceedings, I wasn't actually involved in litigation. I've been sort of studying it on the outside. If you look at the transcripts of the proceedings, you'll see that one of the issues they're focused on initially is weeding out non-meritorious cases. And actually, just about a year ago at this time, the judges in the Middle District of Florida issued an order sanctioning plaintiffs' counsel in that litigation to the tune of $9+ million for prosecuting a number of cases that were frivolous, that should never have been brought because they were time barred, because the plaintiffs hadn't given authority to sue on their behalf. Some of the claims were brought on behalf of living persons when those persons had actually died. There were a number of problems with these cases. In any event, that litigation, I had the opportunity to speak with one of the judges involved in that litigation, Judge Young, actually from the District of Massachusetts. He joined the judges in the Middle District of Florida later on as some of these cases were getting ready for trial. And he indicated to me that he thought that this experiment, if you will, had worked extremely well. And one of the things that you see as you study it is an extraordinary example of judicial collaboration. Each of the judges has a different level of experience, a very different personality, but the individual predilections generally give way to consensus. And one of the things I like about this procedure, and I think it has merit, and I think the JPML should take a serious look at this in the future, is that it provides an opportunity for appellate-style review of key decisions in the multi-district litigation and development of the law without the need for a rule change and without the possibility even of a delay on appeal. Delay on appeal, Mary's absolutely right. The trial court proceedings are not going to grind to a halt simply because someone is seeking interlocutory review. However, if judges grant interlocutory review, it's usually because they've made a decision that this is important enough an issue that it has to be taken up now. And there probably is going to be some delay attendant to the appeal. So you wouldn't deal with that issue, really. You could avoid that concern if you had 3 judges presiding over the district, in the district court, presiding over the multi-district litigation proceeding from the beginning. So that's essentially my my presentation today. Thank you very much for your time.
Thank you all for your presentations. I wanted to remind everyone who's online that you can ask questions using the question box that's next to the viewer screen. I want to see if anybody who's with us here in person today would like to ask a question.
I'd like to ask a very quick question. My name is Richard Sam. I am interested in your idea that there has to be disclosure of third-party funding. I think as a matter of fairness, it makes sense, but what information would be helpful for the actual progress of the litigation? How would information that there is third-party funding affect the way that the case would go forward?
Start with that? Thank you for that question. It can mean a lot to the case. As I mentioned earlier, there are important ethical obligations that are important. And let me make clear when I say third-party litigation funding arrangements, what I am talking about is somebody who is not a party to the case, who has a contingent right to the proceeds in the case, so that if that party wins, they will get a piece of that settlement or verdict. And I think that the rules that are currently in place and have been well accepted in our legal system for ever go to the same thing, that if there are parties with a substantial outcome in the case, that those parties should be known to the people in the court. So that means to the judge and to the parties, for the purpose of making sure that there are not conflicts of interest and other ethical issues. More than that, or in addition to that, I mentioned that there's also this litigation dynamic of knowing who's in the court. This is the same rationale that's used for the disclosure of insurance agreements. that is a relatively new rule that happened during the 70s, I believe, and it was controversial at the time. And there were arguments on both sides about whether that was necessary and important and helpful and all of those other things. But through the process, people understood that when you have an entity that is not a party, that has a significant financial interest in the case, that should be disclosed to the parties so that they understand who's in the courtroom. So I guess rhetorically, I'll ask you, I don't mean to put you on the spot, let me ask this question rhetorically. If you received a complaint, if somebody sued you and you were brought into court, wouldn't you want to know who did it, who's behind it? If it was a neighbor, but that neighbor was getting their money from a hedge fund, wouldn't you want to know that as part of the dynamic of the litigation that's against you, so that you would understand why you're there and also what it takes to get out of the case? One of the aspects that was touched on about third-party funding is that they have their constituents, their investors, and those investors expect something from the litigation funding. They expect a return. And so they are not going to allow or be happy with a return that is not what they were hoping for. And that can create difficulties about settling the case, whether it goes forward or not. And finally, I would say that there are other rules of civil procedure that are important to the case, for which the judge needs to know who the parties are in the case. I'll give a couple of examples. One is in the discovery rules. One of the tests for the scope of discovery is the resources of the parties. So if there is an individual plaintiff in a case and the question comes up, how much discovery should we do in this case? The judge is supposed to know that that's just an individual plaintiff, and there's a limitation to how much discovery should be in the case. If that plaintiff has a $1 billion hedge fund paying the bills, I would hope that analysis is different under the rules, because that's how it's supposed to be. So that's a couple of examples, but I'll leave it with that one.
Just to clarify, I think what we're talking about, the proposal involves is producing copies of agreements. These are contractual. And so, the idea is that parties who are taking advantage of third-party litigation funding would produce copies of their agreements, and that those would be made available not only to the court, but also to defense counsel. And if they needed to be produced subject to a protective order, that probably shouldn't be an issue, but that's what's contemplated, so that everyone can understand precisely how the funding is structured and all the relevant terms.
I would just add, there was a really interesting, I think it was in the New York Times article that was done featuring a pelvic mesh plaintiff who, ended up being solicited for surgery as a consequence of, signing up for a piece of litigation, and they solicited her to, go have this surgery, and I think she had to actually fly to a different state and had the surgery and had a horrible result that was far worse than the condition that she had, prior to this surgery. And there were a whole lot of issues that were very pertinent to the litigation in terms of just the management of her own health care and the fact that she had been, solicited by individuals who were paying. They paid for the surgery and then became, parties in interest, if you will, in her ultimate claim. So it takes many permutations, but the entrance of all of these other different players into the litigation really has changed the dynamic, not just for the defendants who are facing this, but for the plaintiff as well.
So follow-up question from an online viewer. Are the members of the House and or Senate Judiciary Committees at all concerned about third-party funding of litigation?
That's a very good question, and I think the answer is yes. The House last year passed a bill called the Fairness and Class Action Litigation Act. That bill is now pending before the Senate. It's very unlikely to get any action this year, considering we're right before an election for the end of the year. But there's certainly interest in this trend of third-party litigation in Congress.
So if no one else here has a question, I'll ask one, which is, as part of the agenda for tomorrow's meeting of the Rules Committee, Rules Advisory Committee, there was an agenda put out that had an extensive discussion of what the subcommittee had thought about everything that they had seen over the year. We do have that on our website on the page for this program. If you don't want to read the whole thing, it starts at page 139. It's like 700 pages long or something like that. But if you've had a chance to read it, I'd be curious of the participants' thoughts on what the subcommittee had to say in that document.
I just wanted to, I'm sort of setting this up for Mary and for Alex, but we three had an opportunity to be part of the group that met with the MDL subcommittee in September here in Washington. And Judge Bates and Judge Dahl and other members of the subcommittee were present, and Alex helped us set up that meeting so that we could talk about the LCJ proposal, and we got some very helpful feedback from the members of the committee, and this resulted in the report that was generated that you mentioned, Glenn. And correct me if you think I've got this wrong, but I think that there were a few proposals that we made that were of particular interest or concern, one of which I think is the fact that a number of cases get filed that shouldn't be filed, that are clearly non-meritorious or frivolous cases, and I think that's an issue of significant concern to the judges on the subcommittee, and I think probably the advisory committee would be concerned about that as well. And I think the appellate review issue also was another point that was of significant concern to them. But it will be interesting to see, what sort of traction this gets with the larger committee.
Well, I guess I wanted to just add a few things. In terms of reviewing the comments that they made, I think there were a few different themes that were, certainly of concern if you are proposing, MDL reform. One overriding concern was, judges need flexibility. And because, flexibility is so important and all these cases are so, unique and different that, we don't want to hamstring anyone. So the flexibility is the overriding goal. And, let's just set aside due process for a minute and set aside, these other concerns that the defendants has. The most important thing is to give judges flexibility. And again, I think one of the most important comments that was made at the Duke Law Conference, where the judiciary and plaintiff and defense bar and everyone got together to discuss these issues, was made by the chair of the conference at the end. And he said, a lot of these same arguments were made in opposition to the federal rules of civil procedure, where everybody said, oh, no, we need all this flexibility. But the bottom line is, it is helpful to have a transparent judicial set of rules that can be applied. And of course, we all are lawyers, there's exceptions to every rule, but having some of these rules in place would be helpful. The second overriding theme that ran through it was, it's really not that big of a problem. And I think that, it's really hard when the judges who have these cases, have both, very cooperative defense counsel, very cooperative plaintiffs counsel who are, trying very hard to be conscientious and go with the flow and follow this playbook. They really don't see what's happening behind the scenes, in terms of how costly it is, number one, and number two, how this is affecting, our overall clients. So I think that that was my primary concern, was that they really aren't necessarily aware of the full scope of the problem. And number two, I think they're beginning to see the importance of having, transparent rules, but seem to be leaning very hard on the issue of, we want all these judges, to have flexibility. And judges have flexibility in all cases, pretrial management orders and those sorts of things. But, I'm involved in litigation right now where, the summary judgment deadlines were significantly, contracted and not in a way that would be consistent with the federal rules. And it didn't affect our side, but you look at those things and you think, wow, do you get a free pass completely just because you're in an MDL and the rules don't apply at all? It's challenging for both sides at times.
Alex, you wanna-
Sure. I think that to your question about the agenda book, that it's important to keep in mind what that document is. That's a report, an interim report from the MDL TPLF subcommittee to the Rules Committee. It was drafted for the purposes of the committee's discussion tomorrow. Glenn, as you mentioned, the subcommittee has been working for a year to understand MDL procedure and practice. I think they've done a lot of work and have been very thorough, have been open-minded to all ideas. They're obviously taking this topic very seriously, and that memo reflects the right topics, the issues that have come up, the things that practitioners have told them about the MDL process. So that the purpose of that memo is to foster the discussion of what the committee will do next. And I don't know what that is. I think it's a big decision. Obviously, I hope that their decision is to go forward with drafting potential rules and letting the public look at those proposals, but they might not. They might decide not to make any amendments or to propose making any amendments. I think that what Steve said about acknowledgement of meritless claims is really important. The committee has recognized that everyone involved in the process, plaintiffs and defendants alike, agree that there are lots and lots of meritless claims being filed in these cases. And we know from several cases that the rate is probably somewhere between 30 and 50% of claims in these cases that have no merit. And we know that only after settlement, because that fact is not coming out in discovery or trial or appeal. That is coming out after a settlement is made and the claims processors start asking for the very basic kinds of information that Mary referred to. Did you take the product? And that's the step of the process where they're finding out that a huge number of the names associated with these claims have absolutely no relationship to the lawsuit. Never took the product, never had a harm. That's just unacceptable for a civil justice system. And it needs reform, and the Rules Committee is really the only entity with the responsibility and the ability to make that change, to make MDL cases be governed by the rules. We were talking about the 1938 when the rules first came into effect. Before that time, the law was hard to teach and hard to learn, and if you were needed to take somebody to court or were sued in court and you asked a lawyer, I've been sued or I need to sue somebody, what's going to happen? They'd say, I don't know, who's the judge? And that's where we are with MDLs. If these big companies that get sued in MDLs have to hire somebody who knows the judge or has done another one of these cases, because you can't look up the rules in the rule book and find out what's going to happen. And I think that lawyers understand the practice of law to be something different. That if someone walks in your office and says, I need to bring a case or I'm being sued, you can say, okay, well, this is what's going to happen. These are the kinds of discovery that we can ask for, and this is the timetable for it. These are the kind of motions that we can file, and this is what could happen as a result of those motions. But now the best lawyers in the country advising the biggest companies have to say, I don't know whether there will be discovery in this case. I don't know whether there will be vetting of claims. I don't know whether we're going to get appellate review. we'll try to ask for it, and we'll see if we can convince the judge of those things. That's really just completely different from what our civil justice system has been since 1938. And it's time for the Rules Committee to make amendments that bring these big, important cases within the rules so that they are accessible to everyone. Everyone knows what is going to happen in these cases.
I could just add one little comment to a really excellent summary, because I think the subcommittee has been extremely conscientious. But as I was reading their report yesterday on the plane coming here, they were talking about, the whole concept of if you build it, they will come. And yes, a field of dreams, and all I kept thinking was Nightmare on Elm Street. The bottom line is, if you build it, they will come, and that's exactly what's happened. So the question is, how do we now get a grip on the reality of what's happening in MDLs as opposed to just the general concept?
Well, thank everyone for doing this today. We really appreciate it here at WLF, and for everyone for joining us here and online. We will be providing a recording of this if anyone joined us online late, or you want to see it again. It'll be on our website probably later this afternoon. And once again, thank you for joining us today.
Thank you, Glenn.